It is a common error to suppose that every mother has a right to the custody of her child till it attained the age of 7 years. By a curious anomaly in law, the mother of a bastard child has this right, while the mothers of legitimate children are excluded from it. The law as regards children born in wedlock being as follows. The custody of legitimate children is held to be the right of the father from the hour of their birth, to the utter exclusion of the mother, whose separate claim has no legal existence and is not recognised by the courts. No circumstance can modify or alter this admitted right of the father, though he should be living in open adultery and his wife be legally separated from him on that account. He is responsible to no one for his motives, should he desire to entirely exclude his wife from all access to her children. Nor is he accountable for the disposal of the child. That is, the law does not oblige him to make it a bona fide custody by a residence of the child under his roof and protection, but holds the custody of the father to mean, in an extended sense, the custody of whatever stranger the father may think fit to appoint in lieu of the mother. And those strangers can exert his delegated authority to exclude the mother from access to her children without any legal remedy. Should it so happen that at the time of separation or afterwards, the children, being in the mother's possession, she should refuse to deliver them up, the father's right extends to forcibly seizing them, even should they be infants at the breast. The law has no power to order that a woman shall even have occasional access to her children, though she could prove that she was driven by violence from her husband's house and that he had deserted her for a mistress. The father's right is absolute and paramount, and can no more be affected by the mother's claim than if she had no existence. The result of this tacit admission by law of an individual right so entirely despotic is exactly what might have been expected. It has been made the means of persecution and the instrument of vengeance. It has been exerted to compel a disposition of property in favour of the husband where the wife has possessed an independent fortune. It has been put into force by an adulterous husband to terrify his wife from proceeding in the ecclesiastical courts against him. No instance has occurred in which the bad character of the father or the cause of separation has operated on the decision of the courts of law. And though in almost all the cases reported, both counsel and judge admit the severity and injustice of the law as affecting the mother, it does not appear that any attempt has ever been made to revise or alter it. Doubtless, the claim of a father is sacred and indisputable. But when the mother's claim clashes with it, surely something should be accorded to her. Does nature say that the woman who endures for nearly a year a tedious suffering, ending in an agony which perils her life, has no claim to the children she bears? The voice of nature cries out against the inhuman cruelty of such a separation. If the cruelty, hardship, and injustice of the pain inflicted be acknowledged even by those whose province it is to administer the law, if it is only the law which stands against the admission of the mother's natural claim, what hinders that the law be altered? Surely, in this country, where hatred of all oppression is made a national boast, when all liberal opinions are encouraged and fostered, it is a strange and crying shame that the only despotic right an Englishman possesses is to wrong the mother of his children. Shall it be said that there is in England a legal protection for every right and every claim, natural and artificial, except one, And that one is the tie between mother and child.